Let's start. This appeal is directed against his judgment and order dated 8 October 2004 by which the learned additional sessions Judge First Track Court Alipurduar in session trial number 31 of 2004 connected with sessions case number 76 of 2004 within bracket State versus Charumunda convicted the sole accused of an offence punishable under section 304 of the Indian Penal Code and sentenced him to imprisonment for life as also to pay a sum of rupees 5,000 by way of fine in default to undergo further imprisonment for a year. The reasoning adopted by the learned trial court for the purpose of convicting the accused is as follows. In the instant case, the evidence like calling the victim from his house by the accused and the victim last seen together within 2 hours from the death of the deceased and the victim going away from his house and hiding himself for about 10 days soon after the incident, and also he himself being caught by the local people and he is surrendered to the PS, and also he himself offering no explanation, or rather he gave false explanation at a relevant time that he was engaged in work, and also during the period of absence, he went out for work, and such false explanation of the accused is added as an additional link to the chain of the event presented by the prosecution before this court, and further this court is satisfied from proved circumstances here from which interference of guilt of the accused would be drawn only, and thus the circumstance unerringly point to the guilt of the accused, and further all these circumstances when taken together are incapable of any explanation on any reasonable hypothesis that the guilt of the accused, and also those circumstances being consistent and conclusive in nature exclude the possibility of guilt of any other person than the accused pair. Mr. Kollol Mundol, learned counsel appearing for the appellant engaged by the court, submitted that there is absolutely no evidence on the basis of which the appellant could have been convicted of the offence punishable under section 304 IPC pair. Mr. Shanal, assisted by Mr. T, appearing for the state, submitted that this court has to assess the evidence, although he did not dispute the fact that there is no evidence on the record to establish that the disease was last seen with the accused at a material point of time. We therefore propose to look into the evidence adduced by the prosecution pair. The dead body of the deceased was found between 8 to 9 p.m. of the 9th April 2004 by witnesses, which we shall presently discuss. The written complaint was lodged by Srimati Phalo Nagasia, daughter-in-law of the deceased, on 20th April 2004 at about 10:05 hours in the morning, alleging that the accused at around 6 p.m. on 19th April 2004 invited the deceased at his house to perform puja at 9 p.m. She was informed by the villagers that her father-in-law had been killed. The complainant suspected that the said accused had called her father-in-law with the object of killing him, and ultimately the victim was killed by a blunt, heavy weapon. The written complaint was marked Exhibit 5 from the sketch map prepared by the I.O. It appears that the dead body of the deceased was found on the Kata Road leading towards Beniabasra River in between the houses of the accused and one Euta Uran from anti-mortem and homicidal in nature caused by some blunt weapon from the place of occurrence. That is to say, where the dead body was found, a black colored stick, blood stained and controlled earth amongst others were seized by the Exhibit 2. The inquest was conducted at 10:55 hours on 20th April 2004, and on the skull up primary investigation by the I.O. identical information was those appearing from the written complaint were elicited where 11 witnesses were examined by the prosecution and none on behalf of the defense. PW. One is the complainant herself. During her examination in chief reiterated the information furnished in the written complaint. She however added that the dead body was found in front of the house of the accused. She also added that it is the accused who had assaulted and killed her father-in-law. During the cross-examination, they admitted that she did not see the commission of the act of assault. She also admitted that she was informed by the villagers that the dead body of her father-in-law was lying in the road. She also admitted in her cross-examination that near the place of occurrence there was a house of Euta Uran, and the dead body was lying in front of the house. Therefore, the two significant additions which she made during her examination in chief were eliminated in the cross-examination examination, she no more stuck to her stand that the dead body was found in front of the house of the accused or that the accused had killed her father-in-law. Remained during cross-examination, she admitted that she was a follower of Congress party. On behalf of the defense, it was suggested that the accused was a follower of CPIM party. She was suggested during cross-examination on behalf of the defense that neither the accused invited the deceased at his house nor did the deceased go to his house for worshipping as alleged by her, nor did the accused kill the victim. It was also suggested that the victim had been implicated due to political rivalry. The suggestions were, however, denied. Stop bearer. PWs 2, 3 and 4 are the witnesses who had found the dead body lying on the road. All the three had gone to work and were returning home together in their respective bicycle. PW to dispose as follows. It was about 8 p.m. in the night. All on a sudden, my cycle got obstructed by the leg of a man in front of the house of Charu Munda. I then got down from my cycle and found the man who got hold of a lathi is in his hand. As it was darkness, so we could not see his face, but seeing the lathi, we could identify that he was none other than Madho Nagashia of our village. Then I went to his house and called his daughter's wife, who came to the PO with a lamp in her hand. Seeing the man in the light of the lamp, we could ascertain that he was Madho Nagashia, who sustained bleeding, cut injuries on the back side of neck and on face. Madho Nagashia was an old man. She told me that someone called Madho Nagashia from his house. PW3 was accompanying the PW2 when the dead body was recovered. He is in examination in chief. It is supposed that Madhora's wife Halo did not tell us anything as to how that old man died. During his cross-examination, he also disposed that the dead body was lying neither in front of the house of the accused nor in front of the house of Yuta Oran. PW4, another companion of PWs 2 and 3, deposed that seeing the dead body is straight away went home. He, however, added that the dead body was lying in front of the house of the Charumunda, the accused bearer. From the evidence of the PWs 2, 3 and 4, it appears that the de facto complainant within the PW1 though was informed by the PW2 and the PW3 as regards the dead body. She did not divulge to the PW2 that it is the accused who had invited the deceased at his house. She, on the contrary, alleged told the PW2 that someone had called the deceased, whereas the evidence of the PW3 is that the PW1 did not tell them anything as to how did the old man died. Therefore, the story that it is the accused who had invited the deceased at the house of the former for the purpose of performing puja was not supported by PW2 or 3 as regards the location where the body of the deceased was found. The PW2 disposed in his examination in chief that the body was on the road in front of the house of the accused, but in the cross-examination he reports that the dead body was lying on the Kacha road, whereas the version of the PW3 is that the dead body was lying neither in front of the house of the accused nor in front of the house of Yuta Uran. PW4 during the cross-examination admitted that the body was lying in front of the house of the Yuta Uran. PW5 during his examination in chief deposed of that body was lying front of the house of the accused, but during his cross-examination he deposed that the dead body was lying in front of the house of Yuta Uran. PW6, the son of the deceased and the husband of the PW1, deposed that he was not at home in the morning. When he came back, he found the dead body of his father lying on the road in between the houses of the accused and Yuta Uran. The same is also the evidence of PW7, PW8A constable deposed that he had found the dead body in front of the house of the accused, which however is contrary to the inquest report, according to which the body was found in between the house of the accused and Yuta Uran. Preponderance of the evidence is not in favor of the proposition that the dead body was lying in front of the house of the accused. The dead body was lying on the Kacha road, may be in between the house of the accused and the house of Yuta Uran. Had the body been found lying line in front of the house of the accused. This fact would have been indicated by the de facto complainant in her written complaint, which she did not bear. As regards the other important facts as to whether the accused had called the deceased to perform puja at his house, we already have indicated the divergent version of the complainant made before the PWs 2 and 3. PW 6, the husband of the PW 1, however, deposed that he had been able to ascertain from his wife that the accused had called his father from the purpose of performing puja at his house. He, however, admitted during his cross-examination that prior to the incident, my father did not do any puja in anybody's house. PW 7, another co-villager, deposed that I have not seen Madhu Nagasiya worshipping in the house of Charmunda, but I saw him worshipping in his own house. PW 7 also disclosed that the deceased used to perform the job of an oja within bracket exorcist. From the evidence discussed above, we are inclined to believe that the deceased was an oja within bracket exorcist. We are also inclined to believe that the accused may have requested the deceased to come to his house. The reason why we believe so is that there is dependable evidence to indicate that soon after the death of the deceased, the accused disappeared from the village. This also gives the requisite assurance as to the fact that he invited the deceased to come to his house and within hours he died. But the difficulty arises from the fact that there is no information whatsoever as to when did the victim leave his house and when did he go burial. PW 11 is the autopsy surgeon. He deposed as regards the examination conducted by him as follows. On examination, I found large lacerted wound over right eye, another lacerted wound on right occipital. PW 8 and PW 9 are the official witnesses. PW 8 is the constable and PW 9 is the sub-inspector. PW 10 is the local MLA. He deposed that he did not know how did the deceased die. There is no other witnesses, nor is there any other documentary evidence. From the evidence discussed above, following points are established. The accused invited the deceased to come to his house for the purpose of performing some puja. The dead body of the victim was found on the road in between the houses of the accused and Yutauran. The distance between the place where the dead body was lying and the house of accused was 20 to 25 feet, as would appear from the evidence of PW 7 pair. The accused made himself scarce from the date of the incident and was ultimately seen hiding in the jungle by the children, and thereafter the elders were informed the accused was caught, detained, and ultimately made over to the police, as they appear from the evidence of the PWs 6, 7, 9, and 10. The fact that the accused had absconded after the death was also admitted by him. During his examination under section 313 of the Code of Criminal Procedure, in answer to question number 14, he stated as follows: after the death of the old man, I was not at my home as because I went to do job. In answer to question number 34, the accused stated as follows: I did not kill that old man. I am not guilty. On the day of occurrence, I returned my home at 9 p.m. I did not see any dead body. Police had involved me in this false case. I was not in my house after the occurrence as because I went to my place of job. There is no evidence to suggest that the deceased had in fact gone to the house of the accused, nor did anyone see them together. It cannot be therefore said by any stretch of imagination that the victim was last seen together with the accused. It is therefore not for the accused to account for the death of the deceased. In the case of Raman versus State of UP, reported in 1972 within bracket for SCC within bracket notes 6, it was held that absconding by itself is not conclusive either of guilt or of a guilt conscience, for a person may abscond on account of fear of being involved in the offense or for any other allied reason. We are as such unable to hold him guilty. The appeal in the guilt succeeds and is allowed. The appellant is discharged of the bail bound furnished by him. The lower court records with a copy of this judgment is sent down to the trial court forthwith. The urgent Xerox certified copy of this order, if applied for, be given to the practices as expeditiously as possible.
Stop.